to give you the opportunity to have any questions from reporters and such for our speakers.
Does this apply to every business in Ohio or just big businesses?
I think it's Joanne, or it's Joe. Joe.
Oh, okay. I'm sorry. Is it every business or is there a limitation like there is with Obamacare?
It's every business. We have, and it does have a limitation in the sense of employees. So if you have 4, or the way that it's currently we're looking at is to match up with the Pregnancy Discrimination Act that's already on the books with Ohio. That was that Pregnancy Discrimination Act that was mentioned earlier from the 70s. So current law in Ohio has 4 or more employees, so we just matched it.
So if you're a small business that has less than 4 employees, you wouldn't have to comply with this.
Correct. And I mean, that's obviously, this isn't a done deal, so, you know, we'll see where we end up.
Are there specific accommodations that are attached to this?
Yes.
No.
No.
Yeah.
There's no specific accommodation. It's reasonable and temporary accommodation.
Right.
So you heard, from the doctor about the types of things that a stool, a break, a bathroom break, a feeding, a blood sugar check, that sort of thing.
Right, and we have to make sure that we don't codify things that are ultimately left in the hands of the medical professionals that are caring for these women. And so it's going to be, up to the discretion and direction of, the physician that is caring for the woman on what those reasonable accommodations would ultimately, look like.
Does the reasonable and temporary accommodations also apply to, you said, breastfeeding moms, is that correct?
Correct.
And then how would this be more enforceable than the federal law? How would this be enforceable?
There is no federal law.
Sorry, that's my fault.
There's no federal law.
The 78 one was a state law.
Okay.
Sorry.
But how would this, I guess, be more enforceable? You mentioned 1,500 civil rights complaints. I mean, how would this be enforced?
Well, I mean, there would be it would be more clear what is the law, and so that in and of itself remedies a lot of this. So there's still due process that anyone has to go through to prove any type of discrimination. The second thing, though, that I think is really important is that a lot of labor contracts, for example, follow the law in their crafting, and so a lot of times we've seen that where things that are discriminatory in the law get picked up in a labor contract, but pregnancy doesn't because it's not in the law. So there are actual cases where you have men, for example, who receive reasonable accommodation by virtue of the labor contract because they had a DUI and were able to shift their job within the company to maintain employment, even though they behaved in a way that caused them to lose their driver's license temporarily. We think by having this in the law will similarly allow these things to be picked up in labor contracts. So it's not something you have to negotiate to put into a contract separate, but it is, a standard by which labor discussions, move forward.
And just to clarify too, that right now, after the United States Supreme Court ruling, basically what it allows is for these women who have not been given the reasonable accommodations to sue in a court of law for a monetary value. So what we're doing is we're offering an opportunity to have a regulation that businesses can know, and then that way they'd be able to adhere to it.
So there are potential civil penalties, or there are criminal penalties in this for businesses that don't comply?
Let me try to just, no, there are no criminal penalties as far as I'm aware, nor are there explicit civil penalties, I believe, in the state law. I think the issue here is that obviously when the SCOTUS ruling came out about Young versus UPS, that it set up the opportunity basically for a civil tort. And that is going to supersede anything that would be in the state law. The state law is basically just saying, first we're saying, well, you can't discriminate. Okay, well, what does that mean, right? So because we haven't really been able to delineate what does that mean, you have these 1,500 cases that are pending and that have come before the Ohio Civil Rights Commission that don't necessarily have any direction to say, okay, actually this is a clear level of discrimination. So what we're doing by saying you need to have reasonable and temporary, accommodations for your pregnancy, we're saying that if you don't do these things, then when you go through the typical adjudication process, that there actually are some tools to look back to.